You're watching the legal breakdown. So, Glenn, we've got some news here on Jack Smith and the Mar-a-Lago documents case. Jack Smith has now put Trump's attorneys in front of the grand jury. Now, first of all, a prosecutor rarely subpoenas the attorney of the person that they're looking to indict. So, if a prosecutor here is going to subpoena their target's attorney, does that mean that we have a higher likelihood? Does that signal a higher likelihood of an impending indictment for Trump here?
We can't say for sure, but I think, this ups the ante with respect to Donald Trump ultimately being indicted for obstructing justice as part of his unlawful retention of those documents down at Mar-a-Lago. And you're exactly right, Brian. Rarely do prosecutors seek to put a target's attorney before the grand jury because usually there is attorney-client privilege. So this may not sound like a big deal to folks who don't practice inside, the criminal justice system. But I will tell you, in legal circles, trying to take the lawyer who represents the person you're seeking to indict and place them before the grand jury is kind of like a 9 or a 9.5 on the legal Richter scale.
Now, you mentioned attorney-client privilege. The attorneys here are claiming that they can't be subpoenaed because of attorney-client privilege. But the issue at hand here is that Trump is being investigated for crimes that he committed with these attorneys. And so for that reason, this wouldn't fall under attorney-client privilege because of the crime fraud exception. So you've got Trump's attorneys crying out about attorney-client privilege. You've got the DOJ saying crime fraud exception. Which one wins out here?
So if the prosecutors can prove to the judge's satisfaction that Donald Trump was using his lawyers, either wittingly or unwittingly, to perpetrate a fraud, and it sure looks like that's what he was doing, then that we call it piercing the veil of the attorney-client privilege. The attorney-client privilege evaporates, and we can force the attorney to testify about what his client told him to do. So in concrete terms, if we kind of follow the justice breadcrumbs on this one, remember after Donald Trump stole virtually thousands of documents from the federal government as he was leaving the White House, the National Archives started negotiating with him saying, please give us back the property that belongs to the federal government and that is supposed to be housed at the National Archives. And Trump said, no, no, no. He finally ended up giving back a bunch of documents. And lo and behold, there were like 200 classified documents in that first batch that he gave back. And then there was some more negotiation where the Department of Justice and FBI agents started to demand Trump give back all of the documents he had because they had evidence that he hadn't given it all back. So then his lawyer, Evan Corcoran, gave back 30 more documents, classified documents that Donald Trump held on to the first go round. And those 30 documents were presented to the government in response to a grand jury subpoena. And here is where the possible crime fraud comes in. After Evan Corcoran gave back those 30 documents, they did a certificate. They certified that that's it. That's everything. Everything has been given over. Interestingly, Evan Corcoran drafted that certificate, and Christina Bobb, one of Donald Trump's other lawyers, signed that certificate. But then what happened? Well, then the federal government had evidence that that was BS, that he still had more documents. So they had to get a federal search warrant issued by a judge, and they found 100 more classified documents. So now what we knew at that point was somebody lied in that certificate saying we've given it all over. The question is, who lied? And at whose direction was that false certificate drafted and signed? So here's what we know. Christina Bobb went before the grand jury, one of Donald Trump's other lawyers, and apparently testified. We didn't hear anything more about it. Then Evan Corcoran, the other lawyer who was involved in this fraudulent certificate, went before the grand jury, and it looks like he invoked the attorney-client privilege and said, I'm not going to tell you anything more about how and why I drafted up that certificate. And then the big news is the prosecutors are challenging Evan Corcoran's assertion of the attorney-client privilege by saying, no, we believe you were involved in a fraud with Donald Trump. Now, We don't know if he was innocently involved and Donald Trump lied to him and said, we've given it all over, so draft that document saying so, or if Evan Corcoran was in cahoots in a conspiracy with Donald Trump to defraud on the topic of whether everything had been given over. But now what is happening as we speak is the Chief Judge of Federal District Court, Judge Beryl Howell, who has supervisory authority over the grand jury, is litigating the issue of whether the prosecutors can prove that there was fraud involved such that Evan Corcoran can be forced, can be compelled to testify about precisely why he drafted that certification. And I have to believe, Brian, it's because Donald Trump lied to him, because what we know is there were still classified documents in Donald Trump's desk drawer after that certification was drafted and submitted.
Now, will we know, is there a way that we'll be like notified in the public whether that crime fraud exception actually applies?
So we won't know unless, one, there are leaks. Two, there are some really great investigative journalists, and there are a lot out there because that's how we're getting a lot of this information. Or three, here is a sure sign that they pierced the attorney-client privilege. If Evan Corcoran all of a sudden removes himself, recuses himself from the Trump defense team, that will be a sure sign that he has had to testify about the crimes of Donald Trump. And once you testify about the crimes of your client, you can no longer represent the client because now you have a conflict. So keep an eye out in the near future for whether Evan Corcoran removes himself from the Donald Trump defense team.
Got it. Now, what can we expect that prosecutors could learn from Trump's attorneys in this scenario here? Because again, like you mentioned at the top, it's pretty unorthodox for the attorneys of the target to be subpoenaed. So why call them in to testify here?
You know, if they have evidence that Donald Trump obstructed the grand jury process when he was presented with that subpoena directing that he give over all the remaining documents he had, if he engaged in fraud, if he obstructed the grand jury subpoena and the investigation, which it sure looks like he did, you know, that will be sharply incriminating information that the attorneys can provide against their former client. And frankly, we could see an Evan Corcoran and a Christina Bobb take the witness stand at an eventual trial of Donald Trump for the documents crimes at Mar-a-Lago. I have a feeling we could see that.
Could we see something as simple as if the attorney-client veil is lifted, or pierced rather, would we be able to see something as simple as the answer to the question as to who directed Evan Corcoran to submit that statement, that false attestation, basically saying that all the documents had been returned? If he says that it was at Trump's direction, then Trump would be solely responsible for kind of obstructing justice himself in this case.
Yeah, and here is the first time we will see it absent a leak. We'll see it when an indictment is returned by the grand jury, because if Jack Smith as special counsel and his team decide to indict Donald Trump, they're going to issue, I believe, what's called a speaking indictment. A speaking indictment reads like a book. It's where they dump all of the facts and circumstances into a public document, an indictment that sets out exactly how Donald Trump went about committing the crime. So I predict if Evan Corcoran's testimony implicates Donald Trump in obstruction of justice, we're going to see that spelled out chapter and verse in a speaking indictment.
To that point, when can we expect the next milestone here, the next some tangible results out of this case? Because a lot of this is happening behind closed doors. The DOJ is famous for not leaking any of this information, despite how much we want them to leak some of this stuff. So what's the next milestone we should be on the lookout for to know whether or not they'll be moving forward with an indictment?
Yeah, my magic 8 ball is in the shop right now. I wish I had it here to help me predict, and we can't predict. It's impossible to predict, but here's what we can say. Based on a whole bunch of data points, Jack Smith is moving 100 miles an hour, and he's moving in a fearless manner, because when you start to put the target of the investigation, his lawyers into the grand jury, you're getting very close, I believe, to criminal charges. again, if I had to apply everything I learned as a federal prosecutor for 30 years to this set of facts, I could see indictments being handed down, I would say in the next 6 weeks, 8 weeks, 10 weeks, something like that, given the pace Jack Smith has set.
Okay, great. And we'll leave it at this next question here. And that is, we've spoken about this before, but I think it's important to put this into context. What defense does Donald Trump have here? Like, if you were to put yourself in his shoes and just search far and wide for any possible defense that you can put forward in this case, what would that be?
So first of all, he has no straight-faced defense. His best defense would have been, and perhaps still will be, I had no idea what documents were packed up and transported from the White House to Mar-a-Lago. I didn't even put the stuff in my own desk. It was all done by other people. And I'm just kind of an innocent victim of a bunch of sloppy practices by all of those around me. That might have worked had he not posted on his third-rate social media platform that and I can pretty much quote him verbatim, I took these documents from the White House more openly and transparently than other presidents. That admission is going to hang around his neck like an albatross, and I think that will go a long way into knocking down an attempted defense that this really was the product of a bunch of other folks packing stuff up unbeknownst to him.
Yeah, it's pretty amazing how Donald Trump's worst enemy in this entire situation is Donald Trump. And all he has to do to get the benefit of the doubt in a system that's already bent over backwards to help him and people like him, all he has to do is just shut up. And yet he still can't manage to do that to the extent that the biggest piece of evidence against him in this case is an unforced error by him himself. So with that said,
Donald Trump may have the right to remain silent, but he clearly doesn't have the ability to remain silent.
Yeah. Well, with that said, we'll keep a close eye on this case. For anybody watching, if you want to keep up with legal news, make sure to subscribe to both of our channels. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.